Okay, on the record in the matter of the state of Michigan versus William Middleton, 26-00200FY. Council appearance, please.
Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter appearing today on behalf of Mr. Middleton for today's arraignment. At this time, he has made application for the Public Defender's Office, and I would enter a not guilty plea on his behalf.
Thank you. Here, Mr. William Middleton.
Yes, ma'am.
Middleton, I do have a felony complaint here that you are to be arraigned on. Complaint alleges that on or about January 20th, 2026 at the area of 503 East Edgewood Boulevard, apartment 416, which is in Lansing, Michigan, that you allegedly committed the acts in count 1, weapons, firearms possession by prohibited persons, alleging that you did possess a firearm when ineligible to do so because you had been convicted of carrying concealed carry of dangerous weapon, a specified felony that is punishable by imprisonment of more than 1 year, and the requirements for regaining eligibility have not been met. And this is contrary to Michigan compiled law 570.224F6. Count 1 is a felony. Maximum penalty is 5 years in prison and/or $5,000 in fines, and a mandatory forfeiture of the weapon or device is required under the law. There's a count 2, which is weapons, firearms, ammunition by prohibited person. It says that on or about January 20th, 2026 at 503 East Edgewood Boulevard, apartment 416, city of Lansing, Ingham County, the defendant did allegedly possess ammunition when ineligible to do so because he had been convicted of concealed carry of a dangerous weapon, which is a specified felony. That is punishable by imprisonment of more than 1 year, and the requirements for regaining eligibility had not been met, contrary to MTL 750.22F7. Again, that one is also a felony. Maximum penalty 5 years and/or $5,000. Mandatory forfeiture of the weapon or device is required. Count 3 is another weapons, firearms possession by felon. And count 5 also another weapons, firearms, ammunition possession by prohibited persons. Counts 5 and count 6, both weapons, felony, firearm, alleging that on or about January 20th, 2026 at 503 East Edgewood Boulevard in Lansing, Michigan, that you did carry or have in your possession a firearm, that being a 9mm Smith & Wesson at the time that you committed or attempted to commit the felony, that being possession of ammunition by a prohibited person, contrary to MTL 750.227B. Both counts 5 and 6 are felonies. Maximum penalty 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Mandatory forfeiture of the weapon or device is required under the law. Do you understand the counts read in counts 1 through 5, as well as the maximum penalty in each, sir?
Yes, ma'am.
Okay, again, you have the right to be represented by an attorney. Ms. Sutter is representing you for your arraignment. You have applied to have representation through the Office of the Public Defender. You have the right to be screened and represented by the Office of the Public Defender at no expense to you if you are eligible for their representation. So the court will note that you are making such a request and that you are entering a plea of not guilty at this time. You have the right to the presumption of innocence. You're innocent until proven guilty, and you have the right to continue all the way to a trial in this matter, and that being a jury trial. At the time of your trial, you have the right to remain silent and not have silence be used against you, the right to cross-examine or question any witness called to testify against you, the right to call your own witnesses or present a defense to the charges that are being brought against you, and the right to remain silent again and not have that be used against you. What I have here is a probable cause conference that's scheduled and a preliminary examination that's also scheduled. You have the right to have a preliminary examination to establish whether or not there is sufficient probable cause to move forward in this case. So that's sufficient probable cause that a felony was committed and probable cause sufficient to charge you as the individual who committed those felonies. And you have that probable cause conference before Judge Stacia Buchanan on January 30th at 8:30 in the morning. You have a preliminary examination before Judge Buchanan on February 6th at 9 o'clock in the morning. You must appear in person for the preliminary examination, and you should have received a notice to appear while in custody. Do you have that with you, sir?
Yes, ma'am, I do. I have it right here.
Okay, and so you have the right to have that exam within 21 days of today's date unless you find for some reason that you need to waive your timeline and extend it beyond 21 days, or unless the court finds good cause to go beyond that timeline and moves that court date, okay?
Yes, ma'am.
Are you currently employed?
No, ma'am, I get SSI and Social Security. I get Social Security.
What's your home address?
My home address is 503 East Edgewood, apartment 416.
Your phone number?
517-883-3233.
Are you currently on probation or on parole?
No, ma'am.
You can address bond, counsel.
Thank you, Your Honor. I did meet with Mr. Middleton this morning. He did advise me that he is living in the Lansing area. He does reside with his partner and his child. He also advised me that the last prior criminal history he has is 10 years old at this point and was non-assaultive. As far as I am aware today, there are no allegations of violence here. I understand the nature and the seriousness of the allegations regarding firearms, but I do believe it's important to point out that there doesn't appear to be any allegations of use of those firearms or ammunition. Your Honor, he is on disability. He receives SSI and SSD. I do not believe at this point that he poses a danger to himself or the community, nor do I believe he poses a flight risk in this matter, as he didn't recall a prior history of missing court. And I would ask the court today to consider a personal recognizance bond on his behalf. Thank you.
Thank you. Bond in this matter will be set at $2,000 personal recognizance with the following conditions. You are not to possess a firearm, ammunition, or weapon of any kind. You're not to travel outside the state without prior approval of the court. You're not to use drugs or alcohol. No drugs unless you have a valid prescription. Let's see.
I do have a valid prescription. I take Narco.
Let me stop you. I'm not asking you about what you're taking. I'm just telling you you're not allowed to have them without a valid prescription. So you know what you have a valid prescription for. Okay,
yes,
so that I think is self-explanatory.
Okay,
Again,
thank you.
must report to pretrial services within 48 hours of your release from custody. You should have been provided that information from the jail, okay?
Okay. Yes, ma'am.
Lastly, you must make sure you report to all of your future court dates. Do you have any questions?
No, ma'am. My bond is set at 2,000.
Personal recognizance.
Sorry. Thank you, ma'am. I'm sorry. Have a nice day, Judge.
Same to you. State of Michigan versus Eduardo Alejo in 26-00198. Appearance, please.
Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter appearing today on behalf of Mr. Alejo. At this time, he has made application for the Public Defender's Office, and I would enter a not guilty plea on his behalf.
Step forward, sir. Okay, Mr. Alejo, you have a felony complaint here. The allegations are that you committed a home invasion third degree. It alleges that on or about January 20th, 2026 at 710 West Lenawee Street in Lansing, Michigan, that you did break and enter or enter without permission a dwelling at that address, and while entering, present in, or exiting the dwelling, did commit a malicious destruction of a building less than $200, which is a misdemeanor. It's contrary to MCL 750.110A4. Count 1 of home invasion is a felony. The maximum penalty is 5 years in prison and or $2,000 in fines. Do you understand the charge and the maximum penalty?
Yeah.
You have the right to be represented by an attorney. If you can't afford to hire an attorney, you can make a request to have one represent you at the expense of the public, which you've done. You have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You can plead guilty, or you can plead not guilty, or you can stand mute. If you stand mute, this matter will continue all the way to a jury trial. You have the right in this matter to proceed to jury trial and the right to the presumption that you are innocent until proven guilty. You can maintain your innocence, take this matter to trial, and require the prosecutor prove each element of the charge being brought against you beyond a reasonable doubt. You have the right at the time of trial to question or cross-examine any witness called to testify against you, the right to call your own witnesses or present evidence that you believe show a defense to the charges, the right to remain silent, not have silence be used against you. You have the right to preliminary examination within 21 days of today's date, unless you waive that timeline or the court finds good cause to go beyond 21 days. You're currently scheduled for a probable cause conference before me, Judge Kristen Simmons. It's going to be on January 30th at 8:30. You have a preliminary examination on February 6th at 8:30. At the time of the exam, you have the right to have the prosecutor establish that they have probable cause sufficient, that a felony was committed and sufficient probable cause to charge you as the individual who committed the felony. Do you understand your rights here? Mr. Alejo, do you understand your rights?
Yeah.
Are you employed?
No.
How do you support yourself?
I'm living there like with things like I don't
Excuse me?
know now. I don't have a job.
What's your home address?
710 West Lenawee.
That's your home address?
Yeah.
How long have you lived there?
Long time ago.
Your Honor, just to point out to the court, he did not really need one with a conversation with me this morning, but I did find prior cases for Mr. Alejo where a Spanish interpreter was required. I think this would probably be the appropriate time to point that out to the court and maybe suggest one for future court hearings.
Mr. Alejo was before me multiple times, so he definitely understands my questions.
Understood, Your Honor. I just noted previous files where a Spanish interpreter was required.
You lived at 710 Lenawee since when, sir?
Yeah,
Since for how long?
for a few years already.
Okay. Okay, well, you can't live there because the owner or the occupant of that residence says you don't live there. And that's the address in which you are being alleged to have committed a home invasion. So where are you going to be staying, sir?
I don't know now.
When I spoke with him, Your Honor, this morning, Your Honor, I inquired that. He advised me then he would be staying with a friend in the city of Lansing. He did not recall the address offhand. I told him if the court released him and permitted it, he would need to provide that address within 24 hours of his release.
Yeah, well, I just asked him, and I'm the court, I just asked him a question about where is he gonna stay. His answer was, I don't know. So if he can give you more information than he can give me, then I don't feel comfortable with giving him a bond. What's your phone number?
I don't know my phone number.
You're not on probation at this time, correct?
Oh,
You can address bond. I should also let you know that Mr. Lejo has a history of failure to appears and a history of running out of the courtroom.
Yes, Your Honor. He did advise me this morning when I spoke with him that he had some previous failures to appear in court. Again, he did also tell me this morning that he does have an address in Lansing he can stay at. He does not recall it offhand. I understand that's a concern of the court regarding his history in the current situation. I would ask the court to consider a 10% bond, excuse me, a 10% bond on his behalf today, perhaps a GPS tether if that reassures the court.
Thank you. Bond is set at 2,010% with GPS tether. While out on bond, you are not to be at the address of 710 West Lenawee. You're not to be within 2,000 feet of 710 West Lenawee. Do you understand that?
yeah.
You're not to use drugs or alcohol unless you have a valid prescription. You're not to possess a firearm, ammunition, or weapon of any kind. You're not to travel outside the state without prior approval of the court. And you must wear, again, a GPS tether. And you're going to report to pretrial services within 48 hours. Do you have any questions? Any additional matters, counsel?
Nothing further.
You're all set, sir. Okay. On the record, in the matter of the people of the state of Michigan versus Sharon Barkley, I have 22-03425 and 26-00202. Counsel appearance, please.
Good afternoon, Your Honor. Assistant Public Defender Lauren Slutter on behalf of Mr. Barkley. At this time, he has made application for the Public Defender's Office on both files, and I would enter a not guilty plea on both files.
Okay. I'm trying to understand here. It looks like Mr. Barkley has a 2022 file that he failed to appear for arraignment on, but he must have been present before the court a couple of times to set an arraignment and then failed to appear for that set date. He's also filed a letter as late as November requesting to have the bench warrant quashed. So it was set and he still didn't appear. Nonetheless, we will arraign him on, looks like he found several things actually. There's an affidavit of support in here signed by him in October. So that would explain why this was taken out of warrant status twice, but then put back into warrant status. Okay, so on that file, in the 22 file, I have a felony complaint that alleges that on or about August 28th, 2021, that you, in count one, committed the act of weapons carrying concealed, and that you did carry a dangerous weapon, that being a handgun, whether concealed or otherwise in a vehicle operated or occupied by said defendant, that being a Dodge Caliber. And this was contrary to MTL 750.227. Count one is a felony. The maximum penalty, 5 years in prison and or $2,500 in fines, is a mandatory forfeiture of the weapon or device required under the law. It says here, commission of a felony with a motor vehicle advisory, you are charged with the commission of a felony and a motor vehicle was used. If you are convicted and the judge finds that the conviction is for a felony and a motor vehicle was used as defined in section 319 of Motor Vehicle Code, your driver's license shall be suspended by the Secretary of State. You understand the charge there and the maximum penalty, sir?
Yes, ma'am.
Okay, and then in the new file 26-00202, you have misdemeanor complaint alleging that on or about January 20th, 2026 at 4045 River Shell Lane, Lansing, Michigan, that you allegedly assaulted an Asia Dennis, an individual with whom you had a dating relationship without a weapon and did inflict serious or aggravated injury upon her, but without intending to commit murder or inflict great bodily harm less than murder. That's a misdemeanor. The maximum penalty is 1 year in prison, in jail, and or $1,000 in fines. A consecutive sentence may be imposed if the assault was committed in a place of confinement. Do you understand the charge there and the maximum penalty?
Yes, ma'am.
Okay. In the felony file, you have the right to proceed to a preliminary examination. You have the right to have the preliminary examination within 21 days of the date that you are arraigned. So that's from today. You're currently scheduled to have a probable cause conference before Judge Anthony Flores. It's going to be on January 29th at 8:30 in the morning. You have a preliminary examination before Judge Flores. It's going to be Thursday, February 5th at 9 a.m. You must appear in person for both hearings. Do you understand that?
Yes, ma'am.
Okay. At the time of your preliminary examination, you have the right to have the prosecutor establish that they have sufficient probable cause that the felony you're being charged with was in fact committed, and probable cause sufficient that you allegedly committed that felony. You understand those rights?
Yes, ma'am.
In both files, you have the right to the presumption that you are innocent. You're innocent until proven guilty. You can take both matters to trial. You have the right to have the prosecutor at the time of trial prove each element of each of the charges being brought against you beyond a reasonable doubt. You can remain silent and not have silence be used to prove or imply that you're guilty. You have the right to subpoena witnesses to testify on your behalf at your trial, or you can waive silence and testify at your own trial. You also have the right to see, hear, or question any witness called to testify against you. Do you have any questions about those rights?
No, ma'am.
You have the right, of course, to be represented by an attorney. And if you cannot afford to hire an attorney, one can be appointed at the expense of the public. We'll note here that you are requesting the public defender's office to represent you in both files, and a plea of not guilty will be entered on both files. Are you employed?
Oh, ma'am, not right now.
How do you support yourself?
Currently, I'm not in between jobs, so I don't.
What's your home address?
It is 835 Seymour Avenue, Lansing, Michigan 48906.
And that's not the address of the alleged victim, correct?
Correct.
What's your phone number?
517-488-8956.
Are you on probation or on parole?
Ma'am.
Counsel, you can address Bond.
Thank you, Your Honor. I did meet with Mr. Barkley this morning. He did advise me about the prior case from several years ago. It appears to be a reissue that took about 5 months after dismissal to reissue. I believe by that time his address had changed and he wasn't really receiving the notices to appear. He did tell me he'd made some efforts to try and figure out how to address the warrants, and it sounds like from the court there was a couple of things filed trying to figure that out. He does provide an address within the city of Lansing, away from the complaining witness here. He also did advise me this morning that while he's not currently working, he has been seeking work and was hoping to start back with Cardinal staffing within the next week or so, and he's quite hopeful about the opportunity that that might provide him. I believe at this point, Your Honor, with the conditions like the no contact order that I discussed with him this morning, that he does not pose a danger to himself nor the community, nor do I believe he poses a flight risk, Your Honor. I don't think he has any or limited prior record of failing to appear outside of this issue with potentially not receiving notices a couple of years ago. And I would ask the court today to consider a personal recognizance bond on both files. Thank you.
Okay, so I'm just reviewing what was filed. It looks like there was two separate filings by Mr. Barkley. There was the two separate motions, I guess, a notice of what he believed was an appearance, notice to quash a bench warrant and reinstate case, and an affidavit of support of motion, a proposed order to quash bench warrant, and then certificate of service, and then there was exhibits A through D, two separate filings again. In its share, essentially what you have said in addressing bond, that there was a change in address. The problem, I think, is he never updated his address. Even in that, he just gave that he was intermittently staying at a 443 East Edgewood Boulevard. So I don't see where the court ever changed his address. I just see where there was a request from to Judge Flores if he wanted to quash the warrant and set it for a hearing, which he did, but then it doesn't look like anyone appeared. So it looks like there was at least some effort on Mr. Barkley's and to try to get this case moving and resolved. Not the effort he probably should have made in the future, Mr. Barkley. You got to come up to the court if you have a pending felony. You understand that?
Yes, ma'am, I do now. Yeah.
Okay, all right, so for bond on the felony, I'll grant a bond of 2,000 personal recognizance. You're not, both of your conditions are pretty much gonna be the same. And on the other file, there will be a bond of 500 personal recognizance with GPS tether. And the reason for the tether is because of his prior criminal history. Not his first assaultive conviction, and then at least his third time being charged with an assaultive action. And so for the safety of the victim, I think you need to have or the alleged victim, you need to have a GPS tether. You know, to be within 2,000 feet of wherever the victim lives, works, or goes to school. Do you understand that?
Yes, ma'am.
In both files, you're not to possess a firearm, ammunition, or weapon of any kind. You're not to use, purchase, or possess drugs or alcohol. You're not to travel outside the state without prior approval of the court. In file number 22-03425, you do have to report to pretrial services within 48 hours of your release. I also failed to give you your next court date on the aggravated DV. You are scheduled for a pretrial before Judge Cynthia Ward on February 9th at 9 a.m. Okay?
Yes, ma'am.
Yeah, you should have received Zoom instructions. You have the option of appearing in person or Zoom for that next court date, okay?
Yes, ma'am.
Do you have any questions at this time about your bond conditions?
No, ma'am.
Counsel, any additional matters for the record?
No, Your Honor, I was just waiting for the opportunity to ask about the pretrial, nothing further.
Thank you, you're all set. State of Michigan versus Cody Lilly. I'm sorry, I'm gonna do this one. State of Michigan versus Jordan Pierce, 23-02860. Appearance, please.
Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter appearing today on behalf of Mr. Pierce, who at this time has made application for the Public Defender's Office and would like to enter a not guilty plea.
Okay, you're Mr. Jordan Pierce.
Hello, ma'am.
Okay, Mr. Pierce, I do have a felony complaint. Looks like this was a reissued case. This is for weapons carrying concealed, alleging that you did carry a dangerous weapon, that being a pistol, whether concealed or otherwise in a vehicle operated or occupied by said defendant, that being a Lincoln sedan, contrary to MCL 750.227. It's a felony. Maximum penalty is 5 years and or $2,500 in fines, and forfeiture of the device or weapon is mandatory under the law. You understand the charge and the maximum penalty?
Yeah.
Okay, you have the right to remain silent. Anything you say, anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, the matter will continue to trial. You have the right to preliminary examination within 21 days of today's date, unless you waive that timeline or the court finds good cause to waive that timeline. You have the right at the time of the preliminary examination to have the prosecutor establish sufficient probable cause that a felony was committed, and then probable cause sufficient to charge you as the individual who committed the felony. I have you scheduled before me, Judge Kristen Simmons, for probable cause conference Friday, January 30th at 8:30 in the morning. And you have a preliminary examination scheduled before me, February 6th at 8:30. You must appear in person for both. Do you understand that?
Yes, ma'am.
You have the right to a trial and the right to the presumption that you're innocent. So you can maintain your innocence, take this matter to trial, and the prosecutor would have to first prove each element of the charge being brought against you beyond a reasonable doubt before you are guilty. You have the right to remain silent at trial, and they can't use it to prove or imply that you're guilty. The right to subpoena witnesses to testify on your behalf, and the right to testify on your own behalf or maintain your silence and not have silence again be used against you. Do you have any questions?
No, ma'am.
Okay, let's see. Are you currently employed?
No, ma'am. I'm supported by my mother due to the fact that I just had a daughter 3 weeks ago.
I'm sorry, you said you're supported by your mother due to the fact that you just had what?
A daughter 3 weeks ago.
So you left your job 3 weeks ago? Is that what you're suggesting?
No, ma'am. I was in Wayne County. I was on house arrest from Wayne County, and then I moved in with my mother for house arrest, and I had a daughter mid-house arrest.
Okay. So you're not unemployed because you had a daughter, correct?
Correct.
That doesn't really make sense.
No, I was unemployed because I was on house arrest.
Okay.
I was previously at jail time before.
Are you looking for employment?
Yes, ma'am.
What's your home address?
2660 Hamlin, HAMLIN Drive, apartment 102 in Inkster, Michigan, 48141.
Okay, so you're no longer living in Saginaw.
No, ma'am.
What's your phone number?
313-542-5896. And that's my personal cell.
Okay, you say you're on house arrest, or is that over?
That is open.
Are you on probation?
Yes, ma'am, as of yesterday.
You're on probation as of yesterday.
Yes, ma'am. My sentencing date.
That was in
Okay,
Wayne County, Your Honor.
I can see that on your criminal history. Were you on probation in Saginaw before that?
I was, but my height of probation is now completed, and I go back in February 11th to get that finalized. But I paid all my restitution and court fees.
So you're on probation for 2 years out of Melvindale?
Yes, ma'am. Wayne County, Melvindale.
Okay, let's see here. This is a reissued case. I'm not sure what happened in the first case, but counsel, you can address bond.
Thank you, Your Honor. I actually can answer a little bit of that. Jared Austin was originally the attorney on that file. It appears to have been dismissed at preliminary examination because an officer did not appear for the second opportunity at a preliminary examination. The APA at the time advised it would be a reissue, but that took about 5 months for it to occur. So this is quite similar to the previous case where in that 5 months, Mr. Pierce appears to have changed addresses and not received any notice once it was reissued. I don't believe it is an intentional plan of his to evade the court jurisdiction here. He did advise me this morning he was speaking with his probation officer in Saginaw about how to address the bond here and is hopeful about addressing this as quickly as possible and remaining in compliance with his new probation in Wayne County. To that end, he did provide an address that he will be staying at with his mother and his daughter, whom I believe he is the sole caretaker for at this stage, and is hopeful about gaining employment as it is one, a condition of his probation, but also just something he wishes for himself and his family. He did advise me that transportation to any in-person court hearings here would not be an issue, and he would be readily able to provide that transportation for himself. At this time, Your Honor, I don't think he poses a danger to himself or the community, nor do I believe he poses a flight risk, and I would ask the court to consider a personal recognizance bond. Thank you.
A bond is set at 2,000 personal recognizance, no firearms, no drugs or alcohol, no travel outside the state. He must report to pretrial services within 48 hours of his release, and he must attend all of his court dates. Do you have any questions about that, sir?
No, ma'am.
Any additional matters for the record?
Nothing further. Thank you.
Thank you. You're all set.
Thank you.
You're welcome. State of Michigan versus Cody Lilly. And I have file number 25-03713. Appearance, please.
Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter appearing today on behalf of Mr. Cody, who at this time has made application for the Public Defender's Office and would like to enter a not guilty plea.
You're Cody Lilly.
Yes, ma'am.
Okay, Mr. Lilly, I do have here. A misdemeanor complaint that alleges that on or about September 20th, 2025 at 408 East Michigan Ave in Lansing, Michigan, that you committed the act in count 1 of assault aggravated, and that you did make an assault without being armed with a weapon upon Allison Liddell, and did inflict a serious or aggravated injury upon that person, but without intending to commit the crime of murder or to inflict great bodily harm less than a crime of murder. This is contrary to MTL 750.81A1. That's a misdemeanor. Maximum penalty is 1 year and or $1,000 in fines, and a consecutive sentence may be imposed if the assault was committed in a place of confinement. Count 2 is an assault and battery on the same date at the same location, alleging that you did make an assault or assault and battery upon a Kayla Jean Goodell, contrary to MCL 750.811. That's a misdemeanor. Maximum penalty is 93 days in jail and or $500 in fines. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Do you understand the charge and the maximum penalties that are read there?
Yes, ma'am.
Okay, you have the right to be represented by an attorney. Ms. Sutter is going to represent you today for the purpose of your arraignment only. You have the right to have an attorney represent you at all of your court appearances, and if you're questioned by law enforcement. If you can't afford to hire an attorney, you can make a request for an attorney to be representing you at the expense of the public. You have the right to remain silent. Anything you say and anything you put in writing can be used against you. You can plead guilty, you can plead not guilty, or you can stand mute. If you stand mute, this matter will go all the way to a jury trial. You have a pre-trial that's scheduled before Judge Michael Anthony Flores. It's going to be on Monday, February 2nd at 10 o'clock in the morning. You should have received Zoom instructions on how to appear virtually to Judge Flores' courtroom, but you can appear in person if you're not able to appear via Zoom. You understand that?
Yes, ma'am.
Yeah, they are co-defendants. Okay, and this floor is on co-defendant? Yeah. Okay. You have the right again to the presumption of innocence. You have the right to proceed to a jury trial and have the prosecutor prove each element of the charges being brought against you beyond a reasonable doubt. You can maintain silence at trial and not have that be used against you, or waive silence and testify at your trial if you'd like. You have the right to see, hear, or question any witness called to testify against you, and the right to present evidence as to any defenses that you believe you have to the charges being brought against you. You understand your rights, sir?
Ma'am.
Are you on probation or on parole?
No, ma'am.
Are you employed?
Yes, ma'am.
Where?
The Amazon Fulfillment Center.
What's your home address?
420 South Francis Avenue, Lansing, Michigan, 48912.
What's your phone number?
517-803-4957.
Counsel, you can address phone.
Thank you, Your Honor. I did meet with Mr. Lilly this morning. He advised me, just as he's told the court, he is living and working in the Lansing area. He has full-time employment. He also advised me the last criminal conviction he could recall was 8 years ago or over 8 years ago. I do not believe when I spoke with him this morning he knew the complaining witnesses, so remaining away from them in compliance with the no contact order that I explained to him should not be an issue for him moving forward. He does have an address away from the complaining witnesses as I understand it. I do believe with appropriate bond conditions like the no contact order that he does not pose a danger to himself nor the community, nor do I believe at this time he poses a flight risk, Your Honor, and I would ask the court today to consider a personal recognizance bond on his behalf.
What do you say you do for Amazon?
I just work at the fulfillment center. Packages, the new one.
Thank you.
Yes, ma'am.
Bond is set at 1,000 personal recognizance. While out on bond, you're not to have contact directly or indirectly with Allison or Kayla Goodell. You're not to be within 2,000 feet of wherever they live, work, or go to school. You're not to possess a firearm, ammunition, or weapon of any kind. You're not to travel outside the state without prior approval from the court. You're not to use alcohol or drugs unless you have a valid prescription. Do you have any questions about your bond conditions?
No, ma'am.
You also need to make sure you report to all of your future court dates. Any additional matters for the record?
Just, Your Honor, if you wouldn't mind spelling the last name of the complaining witnesses so I can do our conflict check.
Godel.
Thank you very much. Nothing further.
No problem. You're all set.
Thank you.
No problem. State of Michigan versus Zen B 26-00199 SM. Appearance, please.
Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter appearing today on behalf of Ms. B. At this time, she has made application for the Public Defender's Office, and I would enter not guilty plea on her behalf.
Here's Zen B. Okay, I have a misdemeanor complaint that alleges that on or about January 20th, 2026, that's the area of 2121 West Holmes Road in Lansing, Michigan, that you allegedly committed the act in count 1 of domestic violence, and that you did make an assault or assault and battery upon a Jeremiah Edward McVeigh, an individual with whom you had a dating relationship, and that this was contrary to Michigan compiled law 750.812. That's a misdemeanor. Maximum penalty is 93 days in jail and or $500 in fines. Consecutive sentence may be imposed if the assault was committed in a place of confinement. You understand the charge and the maximum penalty?
Yes.
Okay, you have the right to be represented by an attorney. Ms. Sutter is representing you today for the purpose of your arraignment only. But you have the right to have an attorney represent you at all of your court dates, and the right to be represented by an attorney if you're questioned by the police. If you can't afford, again, to have an attorney, you can be screened to have one represent you at the expense of the public. The court's going to enter a plea of not guilty on your behalf. And note that you are making a request for the public defender's office. You have the right to the presumption of innocence. So you're innocent until proven guilty. You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, the matter will proceed all the way through the stages to a jury trial. You have the right at the time of trial for the prosecutor to have to prove each element of the charges being brought against you beyond a reasonable doubt before you are considered to be guilty. The right to see, hear, or question in court any witness called to testify against you, the right to subpoena witnesses to testify on your behalf, the right to remain silent and not have silence be used against you, or you can waive silence and testify on your own behalf. Do you understand those rights? Do you understand those rights, ma'am? I can't hear her. Can you step forward a little bit because you might have a soft voice?
Yes.
Okay, do you have any questions at this time?
No.
Okay, you have a pretrial before Judge Tony Flores. It's going to be February 2nd at 10:30 in the morning. That's on a Monday. You should have received Zoom instructions for how to appear virtually before Judge Flores. You may also appear in person. You understand that?
Yes.
Are you employed?
No.
You said no?
No.
How do you support yourself?
I live with my family. They support.
Okay.
She is a college student as well, Your Honor.
She's a college student where?
Lansing Community College.
You're full-time or part-time?
Part-time.
What's your phone number?
517-803-7607.
What's your home address?
3818 Bayview Drive.
I don't see any prior criminal history. There was a recommendation from the prosecutor's office for a cash bond. I don't know that that's necessary. She doesn't have any prior criminal history. So you can address bond if you like, Ms. Sutter.
Thank you, Your Honor. I would have to agree with you. She also advised me no prior criminal history or any interaction with the criminal justice system. She lives with family. She has an address locally and away from the complaining witness, and she is a student. I don't think she poses a danger nor a flight risk, and I do believe a personal recognizance bond would be more appropriate in this case.
Bond is set at 500 personal recognizance. There's a no contact order that I will set for the protection of Jeremy McVeigh. You're not to have contact with him at all. Do you understand that?
Yeah.
I'm sorry, Jeremiah. It's Jeremiah McVeigh, not Jeremy. You're not to be within 2,000 feet of wherever he is. You're not to travel outside the state unless you get permission from the court first. You're not to use alcohol or drugs, which shouldn't be a problem because you're underage, but if you have a valid prescription, that's a different story. for any drugs that you may have a prescription for. You're not to possess a firearm, ammunition, or weapon of any kind. And you must come to all of your court dates, okay?
Okay.
Do you have any questions at this time? Any additional matters for the record?
Just Your Honor, for a conflict check, is McVeigh EIGH or AY?
It's MCVEY.
VEY. Thank you very much. Nothing further.
No problem.
You're all set.
You're all
Ms.
set,
Lee.
ma'am.
You can go.
The state of Michigan versus Edgar Rivera Perez, 25-03129. Okay, can I have your appearance, counsel?
Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter appearing today for the purposes of arraignment only on behalf of Mr. Rivera Perez. He did advise me that he has retained private counsel, Mr. Robert Akadnicki, who was unavailable for today's hearing. I would enter a not guilty plea on his client's behalf.
Mr. Akanicki been sitting in my court all morning and now, all afternoon, and he just walked out.
Unfortunate timing, but if he's okay with it, I spoke with Mr. Rivera Perez and he was okay with me handling this hearing if Mr. Akadnicki was unavailable.
Mr. Akanicki out there still? I was wondering, he was in my court this morning on LT matter, so that's why I thought he was hanging around. And he's scheduled to be in my court in 6 minutes on an LT matter.
Well, then he should still be around.
He could have told us I would have called this one. Okay, well, we'll call this when Mr. Akanicki comes back.
Very good.
You can have a seat, sir. Okay, on the record in the matter of the state of Michigan versus Zoe Johnson, 26-00205.
Good afternoon,
Appearance.
Your Honor. Apologies. Assistant Public Defender Lauren Sutter appearing today on behalf of Ms. Johnson for today's arraignment. At this time, she has made application for the Public Defender's Office, and I would enter a not guilty plea on her behalf.
Can you step forward, Ms. Johnson?
Sorry, is that?
I just wanted you to step forward, I couldn't see you. Okay, very good. And yours, is it Zoe?
Yeah.
Okay. Okay, I have a misdemeanor complaint here that I'm going to arraign you on. The allegations are that on or about January 20th, 2026 at 310 North Clifford Street, Lansing, Michigan, that you did knowingly make an open or indecent exposure of your person contrary to MCL 750.335A2A. That's a misdemeanor. Maximum penalty is 1 year and or $1,000 in fines. The court shall order law enforcement to collect the DNA identification profiling sample. You understand the charge and the maximum penalty, ma'am?
Yes, I understand.
Okay. You have the right to be represented by an attorney. Ms. Sutter is going to represent you today for your arraignment. You have the right to have an attorney represent you for each court appearance and if questioned by law enforcement. You can't afford to hire an attorney. The Public Defender's Office may be appointed to represent you at the expense of the public. You understand that, correct?
Yes, I understand.
Okay, so the court's going to enter a plea of not guilty on your behalf. And note that you are requesting the Public Defender's Office. You have the right to remain silent. Anything you say and anything you put in writing can be used against you. The right to plead guilty, plead not guilty, or stand mute. Have the right to a jury trial and the presumption of innocence at the time of trial. Yeah, have a pre-trial before Judge Buchanan Tuesday, February 3rd at 10 o'clock in the morning. You should have received Zoom instructions and you can appear in person or via Zoom for that pre-trial, okay?
What?
I'm sorry?
What was that?
You should have received Zoom instructions, so how to appear before Judge Buchanan. Did you get those? It's in your hand, paperwork.
So,
Here we go. What's the matter? You okay?
no. No, when, I thought I was gonna be able to meet. I mean,
They haven't gave you a bond.
okay, so let's just, I'm just ready to leave.
You okay?
So, Ms. Johnson, right now, she's just making sure you have all the paperwork. She hasn't addressed release yet.
Yeah,
What's going on? I'm not following.
I don't want to talk about it. I just leave.
Okay, you can have a seat. I'll call your case when you're ready to talk about it. On the
I'm
record in
ready
the
to talk
matter,
about it. I just,
on
I'm
the
sorry,
record,
I'm ready.
on the record in the matter of the people of the state of Michigan versus Edgar Rivera Perez, a 25-03129. Appearance, please.
Good afternoon, Your Honor. Robert Akinaki. I plan on filing an appearance on this file.
That's my understanding. Is Mr. Rivera Perez ready? Okay, there he goes.
How you doing?
Okay, he's present from from the Lansing City Jail. I do have here a misdemeanor complaint charging Mr. Rivera Perez with count 1 of domestic violence, second offense, stating that on or about July 27, 2025 at 1415 Corvette, City of Lansing, that he made or allegedly made an assault or assault and battery upon a Catherine Ramos Martinez, an individual with whom he had a child in common and or resident or former resident of his household. It says, take notice that the defendant was previously convicted of assaulting or assaulting and battering his or her spouse, former spouse, or an individual with whom he had a dating relationship, an individual with whom he had a child in common, or resident or former resident of his or her household, or of knowingly assaulting a pregnant individual by violating MCL 750.812 on or about March 27, 2024. And therefore, upon conviction, will be subject to an enhanced sentence under MCL 750.814. So that's a maximum penalty of 1 year and or $1,000 in fines, and a consecutive sentence may be imposed if the assault was committed in a place of confinement. You understand the charge and the maximum penalty, sir?
Yes.
Okay. You have the right to be represented by counsel. If you can't afford to hire an attorney, which you have retained counsel in this matter, you could make a request to have the public defender represent you at the expense of the public. The court is going to note, though, that you have retained Mr. Akinaki for this purpose. The court will also note that you're entering a plea of not guilty. That's correct?
Right.
You're scheduled for a pre-trial conference before Judge Cynthia Ward, February 9th at 9 o'clock in the morning. You can appear in person or via Zoom, and you should have received Zoom instructions on how to appear via Zoom. You have the right to the presumption of innocence. You're innocent until proven guilty. You can take this matter to trial and maintain your innocence. You have the right to have the prosecutor prove at trial each element of the charge of domestic violence second offense beyond a reasonable doubt. The right to see, hear, or question any witness called to testify against you. The right to call your own witnesses or present evidence that you believe show a defense to the charge being brought against you, and the right to remain silent and not have silence be used against you. You can also waive your silence and testify to any defenses that you believe you have. You understand each of those rights?
Yes.
Is your client employed?
I'm not 100% sure about the employment status, or if he works for himself. He does have a job that would require.
Are you employed, sir?
Yes, I'm self-employed. I do construction.
Is there a company name?
A1 handyman, and then I got A1 painting.
What's your home address?
Is 1050 West Wieland, WIELAND, and then Road, Lansing, Michigan, 48906.
What's your phone number?
517-249-4911.
Are you on probation or on parole?
Probation.
Before which court?
The one in Kalamazoo,
What judge put you on probation?
Aquilina.
And this address is not the address of the alleged victim, correct?
It's not the address, no.
You're on probation for an interfering with communication device?
Allegedly, yes, yes.
Well, it's not allegedly if you pled guilty.
Yeah, I know. It was with the plea that I had to plead with, but yeah.
You don't have to plead. You
No,
have to
I'm
waive
talking
your
about-
rights to plead freely and voluntarily.
No, when they gave me my plea, I'm sorry. Like that was the plea that was given to me.
Okay, and so the victim of that is Catherine Ramos?
Yes.
That's fine.
My client stays locally. He learned about this charge, and while he is on probation, the first thing he did was talk to his probation officer, told his probation officer he was gonna turn himself in. Then he's friends with a former client of mine. He gave me a call and he turned himself in and came in voluntarily to address this pretty much right away from when he learned of it. I don't think he's a flight risk at all, and I think with no contact order put in place, he's not at any risk to the community, so I would ask for a personal recognizance bond.
I'm not really concerned about him, his appearance or flight risk, that's for sure. The concern I have is I think the risk to the victim, because it doesn't, if I'm looking at his criminal history, I see a pattern at this point. Being charged as a DV second, he's on probation, he's not even supposed to be in contact with this alleged person. In
No,
this case, it's not-
I have contact. The judge Aquilina waived that. The no contact. So we would be able to see each other.
Because they have a child in common, they were able to. see each
Okay,
other.
so I'm sure it was supposed to be peaceful contact. I'm sure that's how that's waived. Nonetheless, you're on probation for interfering with electronic communications with that being the same victim. And there were some very extremely serious charges that were charged in conjunction with that. And I recognize you pled guilty to count 3, but one of those being counts that looked like it was nolly as part of that plea was an unlawful imprisonment and interfering with a crime report, threatening to kill, and domestic and assault and battery. So I do have concerns about the safety of the victim, not of his return to court. So I am going to grant a personal recognizance bond, but it will be with GPS tether. The bond is set in the amount of 1,000 personal recognizance with GPS tether. You're not to have contact directly or indirectly with the protected party.
Okay. Yes.
You're not to be within 2,000 feet of wherever she is while this case is pending. Do you understand that?
Yes.
You will have GPS tether with victim notification. You're not to possess a firearm, ammunition, or weapon of any kind. You're not to travel outside the state without prior approval of the court. You're not to use alcohol or drugs unless you have a valid prescription. And you need to report to all of your future court dates. Which your next court date again is on February 9th before Judge Ward. You have any questions about your bond?
So what do I have to do to get out? What would I have to do? I'm sorry.
Just get GPS. They're just gonna get your GPS tether.
Okay.
Any
All
other
right.
questions?
No, I'll be it. Thank you so much.
Thank you. You're all set.
Thank you.
Sir, okay. Yep.
Thank you. I don't know if you're 3 o'clock is here.
I think I can handle all my language right now.
Okay, wonderful. Okay, is Ms. Johnson ready to proceed? You're back on the record for you, Ms. Johnson. Ms. Johnson, I think we went off the record on your matter after I asked you if you had received the instructions on how to appear before the judge at your next court date. Did you get that?
I got that.
Okay. Okay, very good. So again, I think I've gone over your rights, which includes your right to proceed to trial and have them prove each element beyond a reasonable doubt. Are you employed?
No,
What's your home address?
I don't have a home address. I'm homeless.
You have a phone?
Yeah, I have a phone. It doesn't have a phone number.
It doesn't have service at this time?
No.
Okay, so looking at her criminal history, and it's peculiar to me that since July, and it doesn't appear she had any engagement prior to this, but then since July, she's been in and out of court, none of these in this county. So I don't know if something's going on, Ms. Sutter, but it's like 86 District Court, 63rd District, 62A, 59, and then 59. The last conviction being on this December 16th. But it looks like almost every month she's had some issue. I will be quite frank, even as I read I struggled with issuing on this one because of what I read in the affidavit of probable cause. But nonetheless, I don't know all the details. Based off what I had in limited consumption, I granted the charge, but I don't know if you believe that the client needs to have maybe an evaluation of some sort.
It is potentially possible, Your Honor. I did have a brief discussion with her this morning, but I've had a similar experience as the court this afternoon. I do believe she understands the process of what's going on, but there are potentially some concerns underlying further issues or deeper issues here. So I do believe a personal recognizance bond is appropriate in a case like this, but I do leave it in the court's discretion on this one as I understand the concerns here.
Yeah, I'm not concerned about the personal recognizance. I'm just concerned about, I guess, her overall well-being.
I share the concern, Your Honor. I noted in our application for a social worker to be attached to this case to see if there's anything any resources or support they can provide there.
Yes, because it's, for her to have no engagement with the criminal justice system, and then literally all of the all of the convictions, which are in the last 6 months or less, were all retail frauds, and then now an indecent exposure because of an alleged attempt to use the restroom that was locked, and she's homeless. So that's the concern the court has.
Understood, Your Honor. I don't know that like a CATS evaluation or anything is required at this point. Again, I have already noted on the application for a social worker from my office to inquire
Okay.
about any support or resources. I believe that perhaps internally within my office, we can provide support there. If anything is necessary, I'm sure an attorney from my office would be pursuing something like a competency or criminal responsibility petition. I would also note, yes, the allegations here, you know, it's freezing cold outside, and if someone doesn't have housing, I'm not quite sure what they're supposed to do.
Okay, I'm gonna grant a request for personal recognizance bond, $500 personal recognizance. Ms. Johnson, you need to come back for your court date. If your phone doesn't work, you gotta come in person, okay? I didn't pick up the sound. It looked like she said okay, but the sound didn't register on our end.
Okay,
Okay, do you have any questions at this time?
no,
We're not able to send you a court date if the date changes. That's because you don't have an address for us to send that to. So you're gonna have to make sure you make yourself available to the court. And you should probably also check in with the Office of the Public Defender too. I don't know if there was an email that she could use or that she was provided. That way, if there is resource, they have a way to contact you about that. Okay,
okay.
you're all set.
Thank you, Your Honor.
State of Michigan versus Cameron Wallace, 25-00006.
Herman, I have a hearing and everybody's here for both of those 3 o'clocks.
They're ready to go. I can take them after this. Okay, and you are Mr. Cameron Wallace?
Yes, Your Honor.
Okay, Mr. Wallace, you were supposed to be here for a probation violation arraignment on the 22nd. Right? Right. Okay, it says here that the allegations are that you never enrolled in testing and that you never provided proof of completion of cognitive behavioral therapy. It also states that the defendant failed to report to probation in September, October, and November, and has absconded from probation. So you have the right to have a contested hearing, the right to be represented by an attorney at that contested hearing. If you're found to be in violation of your probation status can be revoked. You can be sentenced to jail time. Do you understand that?
Yes, Your Honor.
He does have an attorney on the underlying matter. Is that correct, Ms. Sutter?
Well, Your Honor, our representation would have concluded at time of sentencing, so he has made a new application for an attorney from my office.
Okay. The court will
Your Honor,
enter plea of not guilty for the violations. You had something
Yes, Your
that you
Honor.
wanted to say? Were you trying to say something, Mr. Wallace?
Yes, Your Honor. My address on this paper right here is my old address. We not currently, but we last month or the month before that got evicted from there, so we don't live there anymore. And I couldn't get my currently now it was 4007 Churchill Ave.
4007 what?
Churchill Ave.
In Lansing?
Yes, Your Honor.
What's your phone number?
I currently don't have one. Use the text now number. I do have an email though.
What's your email?
Cameron Wallace 099 at Gmail.
Counsel, you can address bond.
Thank you, Your Honor. I did speak with Mr. Wallace this morning. He is seeking representation through the Public Defender's Office. I was not aware of the allegations this morning. I do understand perhaps some concern of the court here regarding non-appearance. Mr. Wallace has provided a new updated address to me as well as a phone number to myself, or an email to myself in the court for communication and contact. I did advise him this morning if he is released moving forward, he would need to be participating in probation between now and his hearing and potentially afterwards, depending on the decision of the court here. You know, I understand there might be some concerns here. I would ask the court to consider a personal recognizance bond or a low 10% bond for Mr. Wallace so that he can continue seeking employment while getting back in touch with his probation officer here pending the hearing in February. Thank you.
The judge of record is requesting 11,000 cash surety bond. I'm gonna, judging by what he's just shared, that's obviously not something he could post. Doesn't sound like he can post much less than that either. I'm gonna set the bond at 2,500 cash surety. Did we get a hearing date for this? Okay, it looks like he's set for a hearing February 3rd at 9:30.
Yes, Your Honor.
So if you post that bond as your attorney has indicated, you do need to make sure you make contact with probation and remain in contact pending the hearing. You understand that?
Yes, Your Honor. I'm currently homeless at the time, so I don't think I'll be past making that bond.
Okay, well then you will remain in custody until the time of your hearing. Any additional matters for the record?
Nothing further, Your Honor.
Thank you. We have,
First, I have Edward Rose Associates, the answer.
okay. On the record in the matter of Edward Rose Associates versus which matter, Marilyn? I'm looking at the wrong time, that's why. Tanager Yenser, I'm looking at 11 o'clock. And that's file number 25-07088. You are Miss Tanager Yenser? Okay, and it says in all other occupants, but are you the only occupant?
Yeah.
Okay, so today was a set for hearing. It looks like you all are entering in landlord-tenant judgment. It says that the past due rent to retain $154, and that there's cost of $172.04 for a total of $326, and you'll pay that in full or vacate by February 2nd, 2026. Is that correct?
Yes.
Okay, you understand that you had the right to be represented by an attorney in this matter? Okay, you want to waive that right? Said a yes. You also have the right to proceed to a trial. You could have requested a jury trial in this matter as well. You understand that?
Yes.
You want to waive your right to trial? You have 3 business days from today's date. If once you leave here, you realize you misunderstood the rights that you've given up, you can return, request to have this judgment set aside and explain how you misunderstood your rights, okay? We'll give you a copy of that and you'll be on your way. Any additional matters for the record?
No, Your Honor, thank you.
Thank you, you're all set. And you have one for Stanley?
Yes.
Okay, on the record in the matter of Ahmed Assaf versus Tony Stanley, 25-07068, appearance.
Yes, Your Honor, Robert Document, the attorney for the plaintiff.
Okay, and your name, ma'am?
Tony Staley.
Okay, Ms. Bailey, today was the date scheduled for hearing. This is for non-payment of rent. Counsel, how are you proceeding?
Your Honor, we'd be asking the court for about a month adjournment in this matter. We're going to continue to try for assistance, and we want to have a month to make sure we get to know it.
She's applying for assistance?
Yes. She did apply, and my client didn't provide an adequate ledger, so we're going to.
February 25th at 8:30. February 25th at 8:30.
Thank you.
We'll get you a notice to appear. You're all set. Thank you. Okay, on the record in the matter or matters of the state of Michigan versus Frank Polito, tab 26-00203, 25-02654, 25-01514, 25-01606. Appearance, please.
Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter appearing today on behalf of Mr. Polito. At this time, he has applied for the Public Defender's office, and I would enter a not guilty plea on his behalf for each of the files.
Okay. Okay. Mr. Polito,
Yes,
you are
ma'am.
Frank Polito, correct?
Yes, ma'am.
Okay, Mr. Polito, I have here, I just did that upside down, in file number 26-00203, a felony file with a complaint that alleges that you committed the act in count 1 of controlled substance possession of methamphetamine or ecstasy, and that on or about January 20th, 2026 at 12:15 East Michigan Ave, Lansing, Michigan, that you did knowingly or intentionally possess methamphetamine contrary to MCL 333.74032 BI. That's a felony with a maximum penalty of 10 years in prison and or $15,000. There's a count 2 of police officer assault, resist, obstruct. The allegation are that on or about the same date at the same location of 12:15 East Michigan Ave, that you did assault, batter, wound, resist, obstruct, oppose, or endanger Officer Mark Fox, a police officer of the Lansing Police Department the defendant knew or had reason to know was performing his or her duties contrary to MCL 750.81 D1. That is a felony, maximum penalty 2 years and or $2,000 in fines. A consecutive sentence may be imposed if the assault was committed in a place of confinement.
They're the ones that hit me.
Mr. Polito, I'm going to advise you to use your right to remain silent here.
But they hit me like 5
Mr.
times.
Polito, I would
didn't
not
touch
advise
them.
saying anything further at this stage.
That's fucked up.
Excuse me?
I said it's fucked up
No,
that they are the ones that
Don't swear in my court. Because you have a right to remain silent. You could just close your mouth as your attorney has advised you to do.
I mean, I'm not yelling with you. I mean, I'm just saying.
I don't
they
care.
hit-
I don't want to hear your profane language either.
All right, I'm sorry, I swore, but I got beat up last night for no reason.
Okay,
By
that
these
sounds like it's part of your defense, but your attorney, and maybe you don't understand. The reason why maybe your attorney doesn't want you to say anything on a record that could be used against you is because you have the right to have the prosecutor have to prove each element, including that it was actually you present at that location. She doesn't want you giving the prosecutor any of the evidence by opening your mouth.
All right, thank you.
Okay, I have file number 25-02654, which is another hinder, obstruct, oppose an officer. The allegations in this file. What's the matter with this complaint? Allegations in this file are that on or about June 20th, 2025. That you allegedly at the area of 2400 East Kalamazoo, City of Lansing, did hinder, oppose, obstruct, or resist the officer in the performance of law enforcement duties at that area, and that this was contrary to the provisions of the Code of Lansing being 602.02, and that's a maximum penalty 90 days in jail and or $500 in fines. Do you understand the charges there and the maximum penalty?
Yeah.
Okay, let's see. Did we miss anything? Actually, it probably was already. It was not. Okay. Okay, you have the right in each of these matters to be represented by an attorney. Ms. Sutter is attempting to represent you today for the purpose of your arraignment. But you have the right to have an attorney that will represent you at all of your court appearances, which this is one of them, as well as if you're questioned by law enforcement. If you can't afford to hire an attorney, you can request to have the public defender's office represent you at the expense of the public. Do you understand those rights? I don't know if he responded. I can't hear anything.
I thought I heard yeah, Your Honor, but I'm not positive.
Mr. Polito,
But
did you say what?
yeah, I said
Did you hear me
yeah.
ask you? Yeah, did you
Yeah.
hear me ask you? Are you unable to stand on your own? Is that why you're leaning up against the wall?
I'm fucking pissed, so I'm leaning against the wall.
Well, you stand up.
I got
You can be
charges
pissed off.
there. I got
Yeah,
charges
but
there.
yeah, if you can't control yourself for us to work through this, that's okay. We can set this till tomorrow and then give you some time to calm down.
Yeah, let's do that. Let me go calm
Okay.
down real fast.
Wonderful. Let me remand you to tomorrow and then you'll see the magistrate off the record.
I'll forward it on his application to tomorrow's attorney, Your Honor.
Thank you. Okay, on the record in the matter of the state of Michigan versus Omar Ramza, 25-03851. Council appearance.
Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter appearing on behalf of Mr. Ramza for today's arraignment. He has applied for a public defender, and I would enter a not guilty plea on his behalf.
Okay, Mr. Ramza, let's see. Okay, so I have here a PA 53 bond violation alleging that Mr. Ramza violated the condition of his release, which was not to assault, harass, intimidate, beat, molest, wound, or threaten Anissa, and not to enter the premises or area of 810 North Martin Luther King. And there is a report alleging that he violated that bond condition on or about January 20th, 2026 at 0900 hours. Let's see. Okay, so Mr. Ramza, again, the violation or the alleged violation is that you violated the no contact order. You have the right to be represented by an attorney at a contested hearing on that alleged violation. Your bond can be revoked pending any hearing on that violation. And if you're found to be guilty of the violation, you are facing contempt of court, which is punishable by up to 93 days in jail. Do you understand that?
Yes, ma'am.
He wants to plead not guilty, is that correct? Ms.
That's
Sutter?
correct, Your Honor.
What's your address?
It was 13655 Collingham Drive.
In Detroit?
Yes,
Are you employed?
yes.
Where?
I work at Gestamp.
What's that?
It's making assembly line, making parts for cars.
How long have you worked there?
For like 8 months.
You were arraigned on the 31st by the magistrate. You told her you were unemployed.
No, I was working.
You said it's called the stamp?
Yeah, Gestamp, GESTAMP.
The stamp. Okay. And where is that located?
In Mason.
And you're on GPS tether, correct?
Yes.
Counsel, you can address bond.
Thank you, Your Honor. I did meet with him this morning. He's told me the exact same thing. He just advised the court. I understand the concerns here with the court potentially of any no contact order violations. He is on GPS tether. Obviously, that's going to continue. I would ask the court to consider a low 10% bond for him here. I believe employment is important for him in terms of stability and maintaining a life that is more responsible, perhaps than those who are not always working. That would be my request of the court today. Thank you.
Can I say one thing?
I wouldn't advise it.
All right.
Actually, Your Honor, may I add one thing?
You may.
Thank you. I do recall, and I suspect this is what he wants to add. When I was speaking with him this morning, he was in communication with the tether company regarding the no contact zones. I believe they advised him that the complaining witness was no longer at the address that was previously listed for her. And I believe they advised that meant he was okay to go back there, and I believe that's what may have led to his presence there potentially. It's my understanding that she wasn't presently there. He just was located at the address so listed on the no contact order, and that was
The
after
report I
communication.
have is that he allegedly got in a car.
And Your Honor, that's not information I have.
That she,
Mr.
yeah, that she alleged, at least to the police report, that she was at Speedway and the accused got in her vehicle and took her phone.
I forgot.
That was allegedly on the 20th. However, I do see something else from the 18th. I'm trying to figure out what's happening here. Okay, look, the incident that you're referencing appears to be what's in the report from the 18th. There's a different report on the 20th. So it looks like there's two there actually is, I see the date stamp now. There's two alleged violations.
Understood, Your Honor.
Okay, and so there's also, of course, he's got a no contact order in place from this file, and then a PPO also from the circuit court, and he's on GPS tether. So I don't know, I can understand, I guess, to some extent, if the issue was that he thought that the home was vacant and he returned there. I do see in the report from the 18th some reference of the alleged victim moving. It states that in there, in the report. I also will note that the officer even suggests that the alleged victim changed her statement several times, and that she was maybe under the influence at the time. So I don't really know what's going on here. All I know is that at the end of what's going on is Mr. Ramza facing additional jail time. And I don't think Mr. Ramza wants to, do you like your job, Mr. Ramza?
Yes, ma'am.
Did you want to lose your job because you were sitting in jail?
No,
That happened.
I had a case. I had a case with her before.
Mr.
that was
Ramza, I'm
dismissed.
gonna advise you not
Okay.
to say further on that.
All I'm trying to understand is, do you understand that even a misunderstanding could land you in jail, land you without a job? That could be the beginning of you having a series of unfortunate events. You understand that?
Yes, I understand you.
Okay, and only because the allegations, as alleged, indicate that the officers appeared to have a concern about the change in the story. Am I going to continue your bond at this time? But I'm going to remind you that any further violation, and you're on GPS tether, there should have been victim notification. It does say victim notification. If you're even pinged within 1,000 feet of that, your bond can be revoked. You understand that?
Which address? Her new one or the 18th?
Mr. Ramza, it was a yes or no question.
Oh, yes, yes.
Okay. Now, if there's a situation, I don't know if this was a resident that you jointly owned or jointly occupied, if that becomes vacant, you need to have your attorney contact the prosecutor's office to make sure that's confirmed so that you don't get yourself in trouble. You can't just decide you're going to go back there. Okay. You got to get the prosecutor's office to confirm that she's no longer living there. You understand that?
Yes.
Okay. Any other questions that you have? You should probably talk to your attorney about. Who is his attorney?
Yeah, Tyler Smith, Your Honor.
Okay. You should get in contact. You thought it was who?
Keith, I forgot his last name.
Keith Watson is the former chief public defender. He employs a team of assistant public defenders. Yours specifically is Tyler Smith.
Okay.
Okay, and so your next court date again is going to be on January 27th at 9:30 for both a pretrial and a PA 53, and that's before Judge Buchanan, okay?
All right.
Again, you're not to have contact directly or indirectly with Anissa Reynolds. You're not to be within 2,000 feet of wherever she is. Do you have any questions or concerns about how to remain compliant there?
Oh, ma'am.
Okay, any additional matters for the record?
Just, Your Honor, was there a bond hearing set on this?
I said I was continuing his bond at this time, and that he's gonna have a bond, a PA 53 and a pretrial on the 27th.
Okay, thank you. So the P53 is on the same day. Thank you.
Yep, thank you. You're all set, sir.
What happened?
Your Honor,
Yes,
we don't have record of what the prior bond was. Could you just let me know what that is so I can put it in our system?
it was 2,500, 10%.
Okay, thank you.
No problem. That's all we have.
I think so, Your Honor.
Thank
Thank
you.
you.
Thank you.
Have a good rest of your day.